in yellow tape. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2, Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today because you have a misdemeanor case in this court. Felony cases are divided into, criminal cases are divided into felonies or misdemeanors. The difference between the two is basically the range of punishment. Felony cases are commonly referred to as your most serious type of criminal offenses. Your misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they are not as serious as the felony offense. And when I say serious, I'm talking about the range of punishment. If a person is convicted for a felony offense, there are 5 categories. We have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If you're convicted of a state jail felony, your range of punishment is anywhere, well, it starts off at 6 months to a maximum of 2 years in the state jail and a fine up to $10,000. If you're convicted of a third-degree felony, your range of punishment starts off at 2 years minimum to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you have a second-degree felony, the range of punishment starts off at a minimum of 2 years to a maximum of 20 years, a fine of to $10,000. If you're convicted of a first-degree felony, the range of punishment starts off at a minimum of 5 years to a maximum to 99 years to life in the state penitentiary, a fine up to $10,000. Now, if you are convicted of a capital murder case, your range of punishment is either life or death. Misdemeanor cases are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Your Class C misdemeanors are normally those cases that are in the Justice of the Peace Court or the City Court. For example, a traffic offense is a Class C offense. If a person is convicted of a Class C misdemeanor, they cannot be given jail time. However, they can be given a fine. It is a fine only. The range of punishment is fine only. Now, your case can come to this court on a Class C misdemeanor if your case was appealed from the city court or the JP court. If in essence you want a higher court, which is the county court, to review your case, then you would appeal it. It comes to us, and the range of punishment stays the same, even though it's in county court at law. It's in a county court at law. Now, if you are convicted of a Class B misdemeanor, your range of punishment is minimum 0 days to a maximum of 6 months, which is 180 days in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you are convicted of a Class A misdemeanor, the range of punishment starts off at 0 days to a maximum of 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have other rights. One of the rights that you have, well, you have rights. One of the rights that you have is a right to have an attorney. Now, the paperwork that you have on your clipboard talks about your right to have an attorney. Now, your right to, with regards to your right to have an attorney, you have 3 options, and they're listed on the document that is titled Judge's Explanation of Rights to Defendant Without Attorney. That's the first page of that document. And it reads, as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. And number 3, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. Now, if your choice is, I want to reset this case to hire my own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for a court-appointed counsel or court-appointed attorney, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney, waiving your right to an attorney is giving up your right to an attorney. And if you want to waive your right to an attorney and represent yourself, then you will place your initials on the fifth line, which is the last line, to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your signature on the line that is titled defendant, and you will place today's date, October 11th, 2022, on the line that is titled date. Now, once you finish initialing, signing, and dating this document, those of you who will be waiving your right to an attorney, that is giving up your right to attorney and desiring to represent yourself, then you will have to read and sign the next document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And it reads, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 11th day of October of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign on the line that is titled defendant. You will sign your name on the line that is titled defendant, and then you will place today's date on the line that is titled date. And the day's date again is October 11th of 2022. Now, for those of you who will be requesting a court-appointed attorney, it should be another document there on that clipboard that is titled Affidavit of Injuries. And on that document, what you will be required to do is, there should be a line up there. It says State of Texas versus blank. You place your name on that line. You print your name on that line. And then the information, it asks for your name, your address, whether or not you are employed, whether or not you're married. And you go down a little further, it asks, do you have any children and where do you reside? Where, if you own a home, rent, live with relatives, or you do not have any place to stay, you fill that out information. Now, at the bottom on the left side of that document, it will talk about monthly income. And it has, you say it'll be yours. If you have a job, you just have to state what your take home is for the month on the first line. If you have a spouse who is also working, you'll place your spouse information as well. Now, also, I forgot to mention on that document, above that, it talks about governmental benefits, whether or not you receive SSI, TANF, and some of the other governmental benefits, whether or not you live in public housing. You would have, and I think that line has a highlighter marked through that section. So you would have, if you are receiving any governmental benefits, what you would do is check off the box of the benefits that you receive. Now, going back to the bottom of that document, as I said earlier, on the left side of that document, it talks about whether or not your income. Now, it'll be your income. If you have a spouse, your spouse's income. And it also talks about whether or not you receive any type of child support, if you receive any type of governmental benefits. And then at the bottom, it asks whether or not you have any assets such as a boat or a house. And then what you do at the bottom, once you make sure you fill in everything, now if you don't have none of that information, with expenses, just put zero, put a zero. Now, and then you're gonna total it, on that line, you're gonna total it. Now, on the right side of that form at the bottom, it talks about expenses. For example, if you have a house note, if you pay rent, etc., you'll put what you pay per month there. If you have utility bills, light, gas, water, you add that up and put your utility bills. If you're receiving, if you're paying child support per month, you'll put that on there. Also, it talks about your food expenses. You have to estimate what it will cost for you to pay. What are you paying in food bills every month? Not just what you're eating, but if you're paying, you've got children and everybody live at the house, you got to estimate that per month. And then it also talks about automobile or transportation. Now, when we talk about transportation, we're looking at not only if you have a car note, but if you pay car insurance and if you're paying upkeep of paying gas and stuff. You just kind of estimate it, and then we'll get a value of what you are paying per month. It also talks about if you're paying any medical bills, if you have probation fees, etc. And then what you're going to do in that column is total it. But the court is going to give you time to go through that at the end of what the court is going through. So now we're going to move on to your rights, back to your rights. Now, you have a right, the court mentioned that you have a right to have an attorney. Now, you could either hire an attorney, you can see if you qualify for a court-appointed attorney, or you can waive your right to an attorney and represent yourself. You also have a right to have a trial by jury. And what we mean by having a right to have a trial by jury is you have a right to have 6 citizens from the Jefferson County to be selected to sit on your case, and they will listen to all of the evidence in the case, and then they will decide after listening to all of the evidence, they will deliberate and they will decide whether or not you are guilty or not guilty of the charges. You can waive or give up your right, which means you can waive it means you can give up your right. So you can waive or give up your right to have a trial by jury. And by doing so, your case will come before the court in one of 3 ways. One way it can come before the court if you waive your right to have an attorney. It will come before the court by way of a trial. And when I say it comes before the court, you just have a trial without a jury, and the judge will listen to all of the evidence, and the judge will decide whether or not you're guilty or innocent after listening to all the evidence in the case. Now, the next way your case can come before the court is by way of an agreed plea bargain. What an agreed plea bargain is, a plea bargain is an agreement that you have reached with the state of Texas, with the district attorney's office to settle your case. We call that a plea bargain agreement. So your case can come before the court by way of a plea bargain agreement. And if it comes before the court or the judge by way of a plea bargain agreement, the judge can either follow, which means to go along with the plea bargain agreement, or not follow, which is not go along with the plea bargain agreement. Now, if the judge does not go along with your plea bargain agreement, you will have a right to take it back. In essence, you have a right not to enter a plea of guilty or no contest if you desire to do so, if the judge does not go along with your plea bargain agreement. Now, if the judge does go along with your plea bargain agreement and you decide that, hey, I want to appeal my case. I want a higher court to look at my case. I want the higher court to see whether or not I've been wrongfully convicted or whether or not this court committed an error by convicting me. And if that's the case, if you want to appeal your case, if the judge goes along with your plea bargain agreement and you want to appeal your case, you have to get permission from the judge. And if the judge gives you permission, then your case will go to a higher court. That higher court, ironically, is located right above us. It's called the Ninth Court of Appeal. And they will review your case. They will decide whether they will grant or deny your appeal. If they grant your appeal, they can either find you not guilty, or they could send the case back down to this court and order this court to give you a whole new trial. The other thing is, if they deny your appeal, then you can appeal your case that went up on appeal to another court, to a higher court than the Ninth Court of Appeals. That court is called the Texas Court of Criminal Appeals. It is the highest criminal court in the state of Texas. Now, you would have to file what we call a pro se petition for discretionary review. I will explain that to you. Pro se means without an attorney. Petition for discretionary review, you are asking them to review your case to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not this court committed an error by conviction. Now, if they grant your pro se petition, then they could either find you not guilty, or they could send the case back down to this court, or to this court to give you a whole new trial. If they deny your appeal, then at that point, your conviction will stand. Now, as I said, I'm just going to recap. You have a right to have an attorney, and you also have a right to have a trial by jury. If you waive your right to have a trial by jury, then your case can come before the court by way of a bench trial. That means trial by a judge only, or it could come before the court by way of a agreed plea bargain. That is, it's an agreement that you worked out with the state. The other way your case can come before the judge is by way of an unagreed plea bargain. That simply means that you and the state have not been able to reach an agreement on your case. And because you have not been able to reach an agreement to settle your case, you want the judge to decide what your punishment will be. We call that an unagreed plea bargain. Okay. So again, just to recap, the right to have an attorney, you have a right to have a trial by jury. You can waive your right to have a trial by jury. Then if you do so, your case will come before the court by way of an agreed plea bargain, by way of an unagreed plea bargain, or by way of a bench trial. Now, the other right that you have a right to have witnesses that come to court in your case and testify for you or against you. We call that either direct examination or cross-examination. Now, you also have a right, and basically witnesses, they'll sit in that chair right there. We call it the witness stand. And as stated earlier, they can testify for you, against you. If you represent yourself, or if you have a lawyer, you could ask some questions, either direct examination or cross-examination. Hold on, sir, we'll get to you later. The other thing, let me do this here. Okay, now, the other thing I was saying is that you have a right to have witnesses to come to court. Witnesses either could testify for you or against you. You can ask some questions, or that's either, or if you have an attorney, your attorney can ask some questions. We either call it direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. In essence, you have a right not to call witnesses. You can waive or give up your right to call witnesses. And if you do so, just because you will not be calling witnesses does not mean that the state of Texas will not be calling witnesses, because they're filing a case against you. They will be calling witnesses. Now, you also have a Fifth Amendment right against self-incrimination. Fifth Amendment of the United States Constitution gives you a right not to testify against yourself. In essence, the state of Texas can't force you to testify in your own case because you have a Fifth Amendment right against self-incrimination. I know a lot of times people watch television and you see on some of these shows, somebody say, well, I take the Fifth. That means I'm not saying anything. And I have a right not to say anything. And so you have a Fifth Amendment right against self-incrimination. The other thing is you also have a right to waive your Fifth Amendment right against self-incrimination. Waiving means to give up your right against self-incrimination. And by doing so, what that basically means is you will be testifying in your case. You will give up your right and testify in your case. Now, another right that you have a right to have what is called discovery. Discovery means you have a right to see the evidence that the state has against you in your case. So you have a right to see the documents, you have a right to see the witness statements, you have a right to see the videos, you have a right to see test results, DVDs or audio recordings, objects, whatever evidence the state has against you, you have a right to have access to it. And we call that a right to have discovery. Now, you also have a right to waive your right to have discovery or give up your right to have discovery. And by doing so, you would not be having access to the evidence that the state has against you. Now, everyone in here who's here for arraignment, you're here because you're out on bond. You were in jail, you arrested, you went to jail, and then you're out on bond. You're either out on a cash bond, which means that you paid all of the money, whatever the total amount of the money was, that's a cash bond, you paid that full amount to get out. Or you're out on what is called a surety bond, which means you have a bondsman. Your bondsman got on your bond, and you paid the bondsman a percentage of that bond to get out of jail. Or you're out on what is called a PR, a personal recognizance. That's what PR means. A PR bond means that you did not pay anything, any monies to get out, and you were released under your own personal recognizance. Now, every day that each one of you have spent in jail, that jail time could be used as credit toward your punishment. For example, let's say you spent 5 days in jail and then you bonded out. If you spent 5 days in jail and you bonded out, and let's say you and the state has worked out a plea bargain agreement. The plea bargain agreement is for you, the plea bargain, they agree that you will serve 5 days in jail as the plea. That simply means that you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you will be given credit for time served. You won't have to serve any more time. Now, every day that you spent in jail also counts as $100 per day that will go toward your fine and court costs. And so if the state is offering you a fine and court cost of $500, that simply means you won't have to pay anything. Why? Because you spent 5 days in jail. 5 days in jail at $100 per day is $500. So you won't have to pay anything. Now, if they're requiring that you pay fine and court costs of $700, so what you would have to do is you would have to pay $200 because you've been in jail 5 days. That's $500. 500 from 700 leaves 200. So that means you have to pay $200 on the day of the plea. Now, if you cannot pay the $200 on the day that you enter your plea, then the court can put you on a payment plan. In essence, you can pay off in monthly installments until the $200 is paid off. Now, let's say even if the court did that, because you do not have a job, you don't have the income, you can't pay it off, no problem. Because the court by law can convert your fine and court costs to community service. For example, for every 1 hour of community service that you do, you $12.50 will go toward your fine and court costs. So you get $12.50 for every hour. So if you did 8 hours of community service, that's $100. That will go toward your fine and court costs. Okay? Now, Jefferson County has a program for first-time offenders. That simply means if you haven't been in trouble before, there's a program where Jefferson County District Attorney's Office will dismiss your case and you can get it wiped off your record. How does it work? Well, first of all, it's called pretrial diversion. And in order to get into the program, it has to be your first offense. You have to have an attorney to assist you to get in the program. And the third thing is, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. So for any other charges, you may qualify for that program. In essence, you get in the program, they dismiss your case, you complete the program, you can get it expunged, which means wiped off, deleted, or erased from your criminal record. And if you need information on that, we'll have prosecutors in court who will be happy to assist you at making out the application or sending you to the person or to the department that will examine that application to see whether or not you're eligible and qualified to get into the program. Now, this court, well, also, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has a program that is called Veterans Court. Veterans Court is for veterans only, any veteran, yes.
What if you're active duty?
We probably could get somebody to answer that for you. Okay, we can get somebody to answer that for you, and they'll be able to tell you. Okay, but if you're in there, if you get into that program, it's part of the pretrial diversion program. And so what happens is the case is dismissed, complete the program, and you can get it expunged from your record. Okay, so those two programs, the pretrial diversion program and the veterans program, result in dismissals and expunctions of the case from your criminal history. Okay, and there are paperwork here. We have individuals who probably can answer that question for you or questions that you may have regarding any one of those programs. This court, County Court at Law number 2, has a program that I started in March of 2017 within 100 days of taking office. This program, the CSI program, stands for the Community Safety Initiative. This is a program designed to address the issue of recidivism. Recidivism is where people commit crimes over and over. And so how do we address it? We address it through the CSI program. And with that program, we have partnerships with agencies in our local community. Partnership that we have, you see those young people sitting in that area we call the jury box. They're from Spindletop Center. Spindletop will be able to do private interviews, do assessments, and to develop treatment plans, either outpatient, inpatient, for individuals who have mental health issues. You do not have to be insane. You do not have to be incompetent. You may suffer from anxiety, depression, bipolar, schizophrenia, PTSD, a whole host of other mental issues. They could address those for you. Now, if you have issues with drugs or alcohol, then Spindletop has a program that is called ATAR, and the Alcohol and Drug Abuse Council has a program that is called OZAR. Both of those programs are programs where you will be given a screening, an assessment, and you will can be referred to either outpatient or inpatient to address either your either your alcohol or drug abuse issues. If you are unemployed or you are looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once individuals are trained in any one of those areas that they select, they will assist you at getting the job in those areas, in the area that you select. Now, if you have not graduated from high school, CIC also have a GED program where you could get your graduate equivalency diploma. All of these programs that I have just mentioned, all of these programs are free and they do not cost you anything. Only thing that you have to do is have a desire to be in the program. Okay. Okay. So all of these programs that I just mentioned to you in our CSI program are free, does not cost you anything. Only thing you have to do is have a desire to be in the program, and we'll assist you at getting in the program. The other thing, the other benefit about all of these programs that I just mentioned, all of these programs can be used as community service. So for example, let's say your punishment includes a fine and court costs. And let's say you do not have a job, you can't pay the fine and court costs. And you can't, and even if we put you on a payment plan, you can't pay it. So we order you to do community service. And so you're doing community service, say in the mental top program, either in mental health program, the drug and alcohol counseling, or you're getting trained in the CICE program for a job, or you're working on your GED in one of those programs. Every one of these programs that I just mentioned can be used as community service. So in essence, you're doing one thing, but you're getting credit for three things. One thing is you're in the program. Two, you're getting community service hours. And at the same time, you're paying your fine and court costs. So you're doing one thing, but you're getting credit for three things. Now, as I mentioned earlier, all of these programs are free, does not cost you anything. And these are programs that I started in County Court at Law number 2 in March of 2017. And with these programs, as I stated earlier, they all are designed to address the issue of recidivism, because we're trying to produce productive people. And we believe that producing productive people will not commit crimes. Why? They have too much to lose. And so I tell people this all the time. When you come to County Court at Law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes to this court. And we're trying to make a difference in the community in which we live. We do not just give time, we take our time. We believe that it's better that we don't just arrest the problem, we address the problem. So if you're interested in any one of these programs that we've just mentioned, just let us know, and we'll be happy to give you the information that you need. Now, at this time, we're gonna have Deputy Hinton, who is mental health deputy. He's going to come forward and he's going to talk to you about the Spindle Top program that they have.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state and commissioned by the Jefferson County Sheriff's Office. I'm here with my coworker, Chris. Chris is a qualified mental health professional. The reason we are both here this morning is because the judge is gracious to the violence and support when he cares about every single person who comes before his bench. What the judge has found, what statistics prove, is those who appear with legal issues not only have the mental health, substance disorders, or just lack of community resources. The judge believes that you can get help in those areas, that he can get you out of this life for the rest. I know this is your first time being here. Maybe it's your 10th time being here. You have a program in place where you can speak to you individually and talk to you. Now, I'll pass out a form, a piece of paper, and Chris is going to tell you what we're going to utilize that for and how that form can be helpful to you if you'll fill out the appropriate information so we can contact you at some point in time.
So as our judge mentioned, earlier, we primarily address mental health. Anxiety, suppression, things that naturally come up in the support process. All this is a baseline demographic. It is made and once. Everything on here is considered in the same state law as any other medical information. And resources that you need, again, they can carry by. We do again have the option to speak back there privately. We also connected with a bunch of other communities. As Holmes mentioned, it's not easy to connect with them. There's a lot of things in this area that are well funded and unassumable advertised. There's a few other job training options as well. There's rental assistance. There's resources. And it just depends on what you need. Sometimes as well, since you had mentioned that we were having to be veteran, we do also have veteran. If you are going to be able to be connected with them, they are also involved in events, we have specific resources apply to them. As far as this, we also have the example that Steve can talk about.
So on the back, it tells you a little bit about the court program, why we're here, and some of the benefits by taking advantage of it. On the front, there's also one thing from it. If you ever find yourself in a place, you can call that number and get help immediately. There's also a local number that you can call. You don't have to wait for us to call you. You can call that number, and we will connect with you and get you whatever services that you particularly need for your situation. So there's one thing I'm going to ask you to do. You may be a little uncomfortable, maybe you wasn't prepared to do that, but I'm asking you to share that need with us so that we can help you. It only works if you're able to share that at this time, or when we call you, or you can call us, and we will connect you to a resource that fits your particular situation. You don't know what that is unless you share that with us.
So we're gonna walk around and look things up, and if you have any questions, we will have the answers, we will be more than happy to answer. And we'll also be giving out that pamphlet at the same time, as you mentioned, that 409 number, that is a local office. There's a woman named Lori, should you want to pick up, and you want to talk to somebody from the court building, and she will find that she is very good.
Now, the judge is about to go into recess. When he does, and we will be just visiting with you all and picking with that. Thank you very much. Thank you, Your Honor.
Okay, thank you, Steve and Chris. Now, ladies and gentlemen, the paperwork that you have in your hand, if you need any assistance at filling that paperwork out, we have our court personnel who's here to assist you with filling out the paperwork. Now, once you have finished filling out the paperwork, what we're going to do is pick that paperwork up from you. And then we're going to call you before the bench one at a time, and you will be placed into one of three categories. One, you want to hire your own attorney. Two, you want to request a court-appointed attorney. Or three, you would like to waive your right to an attorney and represent yourself. And so we're going to call you up. It's going to take us a few minutes to do that. Now, in the meantime, if you have to use the restroom, you can go out into the hallways. I think the male restroom is at the end of the hall. Both restrooms are to the right, but the male restroom is at the end of the hall next to County Court at Law number 3. And the female restroom is also at the end of the hall, but it's on the other side next to 172nd District Court. Okay, so at this time, the court will be in recess. We're going to call you up. Once we get all the paperwork together, we're going to call you up one at a time. Again, if you need any assistance, just raise your hand and someone from the court will be happy to assist you. At this time, the court will be in recess